in the interest of time, we're going to go ahead and get started. I hope you all can see the screen here. We're going to talk about Section 111 reporting here today. Lisa, would you like to kick us off and start with the housekeeping items for today's webinar?
Yes, thank you, Heather. Yeah, we have a lot of fantastic content to cover today, so we'll go ahead and get started. My name is Lisa Rice, and I'm the Executive Vice President of Business Development at Sanderson Firm. I'll be your moderator today for the webinar. We appreciate you taking the time to join us for this important topic on Section 111 Medicare reporting, especially as we move forward with the anticipations of fines and penalties being implemented next year. So I'll go ahead and introduce our awesome speakers today. You have two of the top speakers in the industry to discuss today's topic. Heather Schwartz Sanderson holds the distinction of one of the foremost nationally recognized legal experts on Medicare secondary payer compliance. She's an award blogger and sought after national speaker. Heather's known for her cutting edge legal expertise, practical analysis of complex topics, expert technical guidance, and her passionate industry advocacy. Also joining Heather today is Kathy Bell, who is the Vice President of MSP Compliance at Sanderson Firm. Kathy's been in the insurance claims industry for over 30 years. She's worked for both carriers and third-party administrators. She's been in the MSP payer field since 2017. Kathy works with clients on Section 111 mandatory insurer reporting and Medicare compliance to ensure clients across the country are properly reporting their claims and providing valuable insight to customers to assist them with their reporting, data correction, and guidance on reporting to avoid penalties and fines. So I'll go ahead and turn it over to you, Heather and Kathy.
Great. Thanks so much, Lisa. And thanks again for everyone joining here today. Let's get started. We've got a lot of information to cover, and I'm so delighted that Kathy Bell has joined us today as special guest speaker. She truly is a great expert on Section 111 reporting, and I'm looking forward to all getting to know and understand her expertise today. So we're going to talk a little bit about, where Section 111 reporting came from, how it started, an overview for those of you that are not familiar with Section 111. We're going to talk about the looming civil monetary penalties, right? That's the $1,000 per day per claim civil monetary penalty that the Centers for Medicare and Medicaid Services has been threatening the insurance community with for non-compliance with Section 111 reporting. We'll talk about where that's at and also some tips to avoid potential penalties in the future. We're going to talk about the query process and what claims are reportable. Some common misunderstandings that we see in Section 111. We're going to certainly talk a lot about the intersection of Section 111 and conditional payments and how the two play together, and how the CMS contractors and even the Medicare Advantage plans are working off of Section 111 data to drive recoveries, and how important it is that your Section 111 data is lined up and accurate so that conditional payment recoveries are also appropriate and related. So we're going to do that. We're going to take Q&A. As Lisa mentioned, feel free to populate your Q&A at any time in the Q&A chat function. We'll take those at the end, and whichever ones we can't get to, we will certainly get to those later in the future. So for those of you that are not familiar with Section 111 reporting, this became a requirement as part of the Medicare, Medicaid, and SCHIP Extension Act of 2007. Before the MMSEA Section 111 law was passed, Medicare, even though there was the Medicare Secondary Payer Act law on the books, which obviously the purpose behind the MSP Act was for Medicare to pay secondary where primary payer was available. Before this Section 111 reporting law came about, Medicare did not always know about claims and settlements with Medicare beneficiaries occurring, and they were obviously, hamstrung in being able to know what's going on out there as far as recovering conditional payments, as far as coordinating benefits where a primary payer was paying, particularly in a work comp claim. So the whole purpose behind Section 111 reporting is to give CMS transparency into claims and settlements with Medicare beneficiaries so that they can properly implement the MSP, right? So Section 111 reporting requires what Medicare calls non-group health plans. So workers' compensation, general liability and no-fault insurance payers to report or face penalties of up to $1,000 per day per claim. And although the MMSEA law was passed in 2007, it was formally implemented in 2010. We have not seen any penalties be issued by CMS yet, even though we're sitting here in 2023, 13 years later since implementation of Section 111. But things are about to change, so don't get too comfortable, which is why I think there's a lot of interest around Section 111 reporting. We'll talk about it later in a moment, but we believe that penalties will be coming next year in 2024, or at least CMS will have the legal ability to issue those penalties. So I hope that you take great notes in today's presentation. Kathy, why don't you tell us a little bit about ongoing responsibility for medical?
Great, thank you, Heather. Yeah, so let's talk about some of the terminology that is around the Section 111. One of the key data points is your ongoing responsibility for medical, your ORM. Basically, this is the carrier's responsibility to pay on an ongoing basis for medical care for that beneficiary. The trigger for reporting ORM is when the carrier assumes that responsibility or otherwise has a requirement to assume that. We are going to talk in the next slide about some changes that CMS just put into place to kind of give us a little bit more clarification on that. Medicals do not actually have to be paid for ORM reporting to be required. The ORM indicator is a yes or no field, and it starts from the date of loss. So it's not something that you can choose, your ongoing responsibility date. Once you flag it as yes, it is the date of loss. So, for work comp and no fault claims, typically your ORM is going to be yes, because you have that coverage, you have a claim, you have a compensable injury. And so it's going to be yes. On your liability claims, typically it's going to be no. In very, very rare situations that you're going to actually put yes. And maybe those are ones that we need to talk about. If you're looking at, possibly you do need to report yes, maybe it's something that you want to talk further through that. Because all of that information is used by CMS for the conditional payment recovery efforts, which we're going to talk about as we go through the presentation. So again, a very, very, very important key field in reporting your Section 111 data. Now, the workers' compensation claims do have an ORM exclusion. Again, this applies only to your workers' compensation claims. It does not apply to your no-fault claims. So the claim has to be medical only. Your loss time is no more than the statutory rating period, or 7 days if you don't have one. Payments have to be made directly to the provider, so they can't be made to the claimant. And then your total medicals can't exceed $750. So, that claim's not reportable if it meets all of that criteria. However, once it no longer meets that, then that claim does become reportable. So it's important that if you are stopping that process, within your claims data, that you have those notifications in place that once that claim you paid more than $750, that it's looked at to make sure that it still fits within that criteria. So CMS just came out with an update, a version 7.2. So we did do a blog on this about a week ago, but kind of some of the changes were clarification on the date that the ORM termination could be relied upon when you're using a physician statement. So, for example, what they kind of indicated is that if the physician statement states specifically what day the ORM, or that the treatment has stopped, you could use that date. If the physician statement is, doesn't indicate that, then you could use the date of the statement that they indicate that no further treatment is necessary. And then if the statement it's not dated, it doesn't give us indication as to what date it is, then at that point we could just do the last treatment date. Heather, I think we jumped ahead.
Oh, I'm sorry.
There we go. So the second one, this is one that CMS just provided some additional clarification regarding when ORM is required to be reported. So what Medicare has indicated that is if there's a determination made to accept the responsibility for ORM, and when the beneficiary receives medical treatment for that related injury or illness. Medicals do not actually have to be paid, and nor does a claim need to be submitted. So if you are aware of this claim and you know that person received treatment, then the ORM is required to be reported. And again, they clarified that the effective date of ORM is the date of injury regardless of when they receive their first treatment or when ORM is reported. So they kind of gave us some additional clarification on that. They also clarified that the no injury claims are no longer required. So this is going to be for your loss of consortium claims or your personal injury claims where they're not claiming any medicals. But if they've indicated that, you know, on your personal injury, be careful, because if they've indicated that they had a stress claim and that there may be some medical treatment related to that, then you do need to be careful using that no injury claim. And again, that's something that we can certainly assist in reviewing the facts of that case to help you with that. And then the last is that the unsolicited response file. So now they did clarify the only entity other than the RRE, so that can call and update the records, is through the BCRC, and they have to verify that it is the beneficiary that's calling. So that was a really significant clarification that they provided to us. And again, we had more information on our blog, and encourage you to go out and read that. And if you have questions, then let us know.
Okay, so let's talk about what TPOC is, the total payment obligation to claimants. Essentially your settlement, right? It's the amount of your settlement, judgment, award, or other payment apart from ORM. It's generally a one-time settlement, judgment, award, or payment, although there can be multiple TPOCs. And it's required if payments for medical care are claimed or released and the settlement or judgment has the effect of releasing medicals. But it's important to note that indemnity-only settlements that do not release medicals do not need to be reported. And also the computation of the TPOC amount is, you'll see all these items here on the screen as far as like Medicare covered and non-covered medical expenses, indemnity, attorney's fees, all of that. It's the same way that you compute the total settlement amount if you're going to submit an MSA to CMS. It's the same computation, the same way that the settlement amount is computed for the purposes of TPOC. It's really important that TPOCs are reported timely. And also the TPOC date, we get this question a lot. It's the date that the obligation is signed if there's a written agreement, but if court approval is required, it's the date of court approval or the date the obligation is signed. If it's no written agreement, it's the date that the payment is issued. So generally we see every November or so, ever since the SMART Act was passed back in 2013, that CMS must compute an annual threshold in which they will not require Section 111 reporting or recovery of conditional payments. So, you know, a number of years ago, before the SMART Act of 2013 was passed, Medicare was recovering and requiring the reporting of low dollar claims. And it just doesn't make sense, right? Because Medicare is then spending more money on its recovery than it's actually recovering, right? So SMART Act required Medicare to set a threshold. It's been $750. So if your settlement is $750 or less, then you don't have to report the settlement to CMS. It's been that threshold for, I'd say, the last 4 to 5 years now. We keep seeing every year CMS keeps publishing the same threshold. I would have expected that that threshold would have gone up to at least $1,000 by now, and I'm hoping to see that come this year. I do think that Medicare is probably spending too much time on some of these lower dollar threshold settlements, but it's important to note that you're not going to report these settlements below the threshold.
Now let's talk about you know, another really key data point, and that is your ORM termination. So we've reported, you know, we've talked about when you report ORM. Now, how do you terminate it? Because that's what tells Medicare this is their coverage period. So again, your ORM is from the date of loss. And then we want to tell Medicare, when does your responsibility end? And the way to do that is by putting in a date. Medicare has given us criteria on, you know, the reasons that we can terminate ORM. And what they've said is that when there's no likelihood of future treatment, so basically a release from care with no further treatment. Unfortunately, Medicare will not, you know, accept it if it says, you know, MMI, treat PRN. Then Medicare has, you know, indicated that's not a release from care, no further treatment. So we, you know, do need that specific language that says no further treatment is necessary. A TPOC or your settlement that fully resolves medicals. You need to make sure that, you know, on those workers' compensation claims, when you're settling out the medical portions, that you're also going in and terminating your ORM, because you want to make sure, again, that you're telling Medicare, here's that coverage period. Statute of limitations. So if you have a state that has, let's say, a 2-year statute of limitations, then you would want to make sure that you're putting in that statute of limitations as your ORM termination date. Other state law, so for example, Georgia has the 400 week rule, so you could terminate ORM based on that. So it's just so important that we are getting that information in. Another one, and this probably is more for your no fault claims, so for your MedPay and PIP claims, and that would be the time limit that's based on your insurance contract. So you have a statute of limitations as far as you have 1 year of coverage. So you'd want to make sure that you're terminating that ORM after that 1 year to, again, tell Medicare that's what the coverage period is. Or if you exhaust the limits. So most of your MedPay policies may have $5,000, $10,000 limit. Once you exhaust that, you would want to make sure you're terminating your ORM. But in addition, you also want to make sure that you indicate that you have exhausted that no fault limit. So it's important that you're putting both of those data points in there to tell Medicare that you've exhausted that coverage. And then CMS, they listen to the insurance community, and we had all these minor injury claims where somebody treats, but then they never go back to the doctor, so you never get a release from care. So CMS gave us some further guidance on this, and so what they said was if it meets all of the following criteria, then you could terminate ORM. So what they said is that you can't have a diagnosis code for ingestion, implantation, or exposure. The medicals, you haven't paid anything within the last 5 years from the last treatment date. The treatment does not include medical implantation or prosthetic device, and the total amount of the medicals is less than $25,000. So if it meets all that criteria, then you could go ahead and put in your ORM termination date, just knowing that if for some reason something changes and it no longer meets one of those points, then you would have to open up ORM. And again, that's going to be back to your date of injury. So, again, it was just, it was nice for CMS to give us that further guidance to be able to terminate these ORM cases. So again, when you are terminating ORM, you do not want to change your ORM status from yes to no. The ORM status still remains yes, but the way you terminate it is by putting in that date. And again, that defines your coverage period. So let's go ahead and go to the next slide. So who, what, and when to report. So the first part of the Section 1 process is the query process. This is a very, very important step because this is what's going to tell you whether that person's a Medicare beneficiary or not. Yes, you can ask the claimant, but a lot of times they're not going to give you the right information. Sometimes they don't know, or, they're not going to tell you. So it is important to, get this query information, and I highly recommend getting it as soon as possible so that it can go through the query process, because knowing that you're dealing with a claim that involves a Medicare beneficiary gives you that ability to be able to have further conversations up front with the claimant as you're going through the claim process. So we refer to it as the Big Five. So it's Social Security number. You can use the HICN or the MBI, which is the Medicare Beneficiary Identifier, first name, last name, date of birth, and gender. So you want to get all those data points in there, and then Medicare will come back to tell us whether they're a Medicare beneficiary or not. Once we know that we have a Medicare beneficiary, then we have to look at, is that claim reportable? So first, kind of the first step in determining if the claim is reported is looking at the ORM, your ongoing responsibility for medical. If it's yes, then that claim is now reportable. And so all that data information is going to go over to CMS to let them know that you have a claim. Another step is the TPOC, or your settlement. If it's over that current threshold, which is $750, then at that point, that claim is now reportable to Medicare. For workers' compensation claims, if you have a settlement that's releasing those, for future medicals, again, you would also want to terminate that ORM at the same time. And then the fourth step is, again, terminating that ORM, making sure that you're terminating it properly, but, terminating it when you can. So, when the statute of limitations is ran, make sure you get it in there. You've exhausted the limit, make sure you're getting that in there. It's just so important, again, that we're telling Medicare when that coverage period is, so that they know for their recovery efforts on those conditional payments what that is. Other times that you might want to make sure that you're re-reporting that claim is looking at ICD codes. You want to make sure that you're looking at ICD codes throughout the life of that claim. because you may have to add ICD codes. Maybe a new condition arose and you have to report that, or maybe a condition actually resolved and you have that release from care on that specific ICD code. You'd want to remove it. So you're just wanting to make sure, and if there was anything else that was reported improperly, maybe you had ORM is yes, and you reported it improperly. You want to make sure that you're updating that information to Medicare, or maybe somehow a TPOC got reported improperly. You want to make sure that you're just updating that information as you're handling that claim.
Very good information for sure. Well, let's talk about, the 1,000-pound gorilla in the room, the proposed rule that is potentially going to become final in February of next year, which would allow CMS to impose penalties of $1,000 per day per claim, right? So for those of you that are not familiar, so Medicare, even though they were allowed $1,000 per day per claim for penalties as part of the MMSEA law, when the SMART Act of 2013 was passed, it required CMS to now use discretion when issuing penalties. So the language changed from a mandatory $1,000 per day per claim penalty to a more of a discretionary penalty of up to $1,000 per day per claim. So Medicare needed to actually legislatively rule-make around when CMS could actually issue penalties before they could do so, right? So they needed to do this in the form of legislative rulemaking. We saw that in February 2020, CMS issued their proposed rule on those scenarios that they would likely be focusing in on if and when they do issue penalties. So I think it's important that we cover those. We don't know 100% what will be in the final rule when it's released next February of 2024, but I'm willing to guess that it's going to look very similar, right? So in response to all these, initiatives that Medicare has provided, the industry did give commentary back to CMS to consider when releasing their final rule. So we'll see. But let's talk about what was in the proposed rule. So one of the main focus areas in which CMS said they would issue penalties is if the responsible reporting entity fails to report a TPOC within the required time frame of 1 year. Now, that's a pretty generous time frame, right? Because quarterly reporting happens, so you should be reporting your TPOC in your next quarterly reporting following your TPOC. But if for some reason it's delayed, CMS is giving a grace period of up to 1 year. Now, the second area of focus within the proposed rule, which kind of surprised many of us, and I think would be the most difficult to implement, is where there's a discrepancy between your Section 111 reporting and what you're telling CMS's recovery contractor. So I think probably one of the main areas, and I believe the example that was provided in the proposed rule was around ORM termination. So you just heard Kathy giving you a lot of great information regarding why it's so important to terminate ORM in the scenarios in which you can. Let's say ORM is not terminated timely, right? But you do in fact enter into a settlement with a Medicare beneficiary and forget to terminate ORM or potentially forget to report a TPOC. You now get a conditional payment letter in from Medicare with charges that are outside of the date, let's say a few months after your settlement, and you're thinking, wow, I'm not responsible for these charges because we had already settled the claim at this point in time. So we go and we dispute with Medicare's contractor saying these charges should be removed. They're post-settlement, they're not our responsibility. But so you might win on the conditional payment dispute, but Medicare could now issue a penalty for that scenario because the CMS contractor was working off of the Section 111 data, which told them because you didn't terminate ORM, they thought the claim was still open and they thought that they could pursue those charges. So you sort of, I think what Medicare is getting at is you're kind of wasting the contractor's time if you're not having accurate reporting going into the contractor. So in that example I just gave you, while you might win the conditional payment dispute, more hefty would be the actual penalty coming from CMS because your Section 111 information didn't reflect what you were telling the contractor. So really important to terminate your ORM timely and to get those TPOCs in timely so that there's no discrepancy between what's being told to the contractor. Also, error tolerance thresholds. Currently, 20% would be the maximum in which CMS would allow for errors. Many individuals don't know this, or organizations are not aware of the importance of correcting those errors that come back from CMS in your Section 111 reporting. In fact, if those errors are not corrected, it's just like it's not been reported at all. So you really want to make sure, depending on how you're doing reporting at your organization, that those errors that are coming back are being timely corrected and addressed. Also, within the proposed rule on penalties, Medicare let us know that they intend to apply a 5-year statute of limitations. So a couple of comments on that from my perspective, from a legal perspective. So many of you might know that within the MSP Act, the statute of limitations is 3 years for Medicare's conditional payment recovery. So now we have a different SOL for reporting, which would be 5 years. So I think that's interesting. I know that the industry as a whole, and I've commented back to CMS that the statute of limitations should be 3 years in line with the MSP and not 5, but we'll see what's in the final rule. And where I think is also a contradiction in the proposed rule, and it's interesting to look at, is that although the proposed rule said that any penalties that would be issued would be prospective in nature, right? So after the effective date of the proposed rule, CMS also did include this proposed statute of limitations of 5 years. So when you kind of take the two in conjunction, thinking about it, right, we've had companies ask us, how far back should we go to fix our data? Isn't the Medicare proposed rule or the final rule when it comes out only going to be prospective in nature, so we don't need to fix our data? Well, I think there's an issue here, because if you've not triggered Medicare statute of limitations by reporting the settlement, then technically Medicare would still have a right to pursue penalties. So let's say your organization settled a claim with a Medicare beneficiary back in, let's say, 2017. But the adjuster on the file failed to report the TPOC, right? So Medicare has had no reporting of the TPOC settlement. Then the statute of limitations is not triggered and Medicare could go backward. So we do recommend going back a number of years. Now is really the time to make sure that your data is cleaned up. We know that the draft of the proposed final rule is currently sitting at the White House OIRA office, right? So it's undergoing a conflict check. And right now, the Federal Register tells us that Medicare will be finalizing this final rule in February of 2024. It seems like, especially particularly with COVID and a number of other initiatives going on at CMS, that, CMS had to delay the rule. It was supposed to be released this February, but nonetheless, we're thinking it's going to come next year. Medicare could have just withdrawn the proposed rule and started all over, but they're clearly moving forward. There will be an appeals process for assessment of civil monetary penalties. It's not like CMS can just issue penalties without the opportunity for the responsible reporting entity to, provide evidence as to its good faith efforts to report. There were some safe harbors within the proposed rule, right? So some areas in which CMS said, you know what, if this is available to us and we can see that you've done certain actions, we're not going to issue penalties. So particularly another focus area in the proposed rule was around collection of Social Security numbers, right? So Kathy told you all earlier about the big 5 that we need to report and to do the query, right? To determine whether someone's Medicare eligible. If we don't at least have a partial Social Security number or the whole Social Security number, then you can't query and you can't report the claim, right? So Medicare wants to see that the RRE has documented those good faith efforts to obtain a Social Security number. Now, obtaining the Social Security number is not as big of a concern in work comp claims, right? Usually the employer carrier has that information. But in liability claims, we do see this quite often. We most recently audited a large liability insurance carrier that had well over 70 or 80% of Social Security numbers not collected, no documentation in the file as to attempts. So it's a good thing they're getting in front of it right now, and now they're implementing this program. What I suggest to you all is kind of getting in line with what CMS suggested in their proposed rule, is that you need to have 3 attempts to obtain the social, 2 by mail, and then also 1 request by phone or email. In the meantime, also CMS has given us this nice affidavit that allows you to have, I'm going to just jump ahead, where is it? Right here. If you can't obtain the Social Security number to query, utilize this form. If you need a copy of it, please email any of us. This is what the injured party will sign off on to say that they were unwilling to provide their social security number. I'm going to jump backward. Okay, so we're kind of already on the query topic here. Kathy, do you want to tell us a little bit more about the query process, which is done monthly?
Sure. Yeah. So as Heather mentions, the query process, and again, as I kind of talked before, this is, again, a really important step in that first reporting, the Section 111 reporting. So it is done monthly. You can only submit one file through the Section 111 data monthly, but it is required that you have the 5 data points. So again, first name, last name, date of birth, social security number, or their Medicare beneficiary identifier, their MBI, and gender. I will tell you, Medicare is accepting you as a gender, so you can put that, and that will go through the query process. During that query process, there is no exchange of specific claim data. All it is that those 5 data points are bumped up against Medicare's database, and Medicare says whether they have a match or not. Medicare uses the social security number and then matches 3 of the remaining 4 data points to determine if there is a positive match. Now, if you only have provided the last 5, which Medicare will accept, then they are going to match all 4 data points in order to determine if that person is a Medicare beneficiary. As part of that PAID Act, or as part of the query response file, and with the PAID Act going into effect, Medicare is now providing us back Part C, which are the Medicare Advantage plans, and the Part D prescription drug coverage plans for the last 3 years up to those 12 incidents. So again, it's really important that those claims are going through that query process, because not only are you determining if they are a Medicare beneficiary, but you're also getting that PAID Act information, which is going to be so important as you're moving forward with these claims. And if you're going to get ready to settle them, you want to, make sure you're being proactive. And I think Heather's going to talk about that in the next slide.
Yes, definitely. So the PAID Act, right? And so much commotion around Medicare Advantage plans in the last few years. I could talk about this for the whole presentation, but I'm going to get to the point. I think it's really important, especially post PAID Act, that you're paying attention to the data that's coming back in your query response file. So just a bit of history. Before the PAID Act, which was passed in December of 2020 and effective in December of 2021, during the query process, Medicare was only returning the Medicare Part A and Medicare Part B traditional Medicare enrollment information to responsible reporting entities. And this was a problem, right? Because currently, and as it stands right now in 2023, 50% of the Medicare population has opted for a Medicare Advantage Part C plan rather than enrolling in traditional Medicare. So that's a significant portion of your Medicare population. And then we have over 90% of the Medicare population enrolled in a Part D prescription drug plan. And now why that's important is because Medicare's contractors that do their recovery of conditional payments, the BCRC and CRC, do not handle and do not provide information or do the disputes or recoveries on Medicare Advantage or Part D conditional payments. That all comes from the Medicare Advantage plans or the Part D plans themselves or their recovery agent, right? And so now that you're getting in the query response file, because the PAID Act was a simple 1-page bill that simply required CMS to return the Medicare Part C and the Medicare Part D enrollment information to responsible reporting entities so that they can take that data and be proactive with it should they choose. We're not getting a surprise many years post-settlement, right? So you're getting this information back. Let's say you run a query on one of your claimants. Her name is Jane Smith, and Jane Smith is on Humana Medicare Advantage, right? That comes back in your query response file. What we would recommend doing there is reaching out or having Sanderson firm reach out to Humana to determine if there is a lien there and to proactively resolve those conditional payments. Now, there's no requirement to do that, but if you don't, here's what's going to happen. Medicare does share your Section 111 data with the Medicare Advantage plan so that they can pursue their recovery. So you go and settle your claim, and if you don't go and resolve that Humana conditional payment lien with Humana, then after your settlement occurs and CMS shares data about that settlement taking place with Jane Smith, you're now going to get a conditional payment demand post-settlement, which is not what you want, right? You want to resolve these pre-settlements. Also, you want to avoid the potential for these Medicare Advantage plans to file a double damages cause of action against your organization for failure to reimburse them. The Medicare Advantage plans, hands down, are far more litigious, far more scary, I would say, right now in today's MSP environment as far as pursuing recovery of conditional payments. We have 3 circuits in the United States, 3 circuit courts of appeal that have found that Medicare Advantage plans have the same double damages private cause of action rights of recovery as Medicare does. So really important. The PAID Act is giving you the transparency into that Medicare Part C and D information. Utilize it, be proactive. Something that we're also seeing, by the way, if you're looking to settle a claim and you want to get all these Medicare Advantage plan conditional payments resolved, is that start the process early. We've been working with many of the Medicare Advantage plans across the country now in resolving these Medicare Advantage plan conditional payments on behalf of our clients. Some of them are really quick to respond to us, but one particular very large Medicare Advantage plan has told us that they're 6 months behind in responding to initial lien inquiries. So if we, let's just say that Jane Smith actually had that particular Medicare Advantage plan, which was not Humana, but a different one, they're 6 months behind even letting us know initial lien amount. So doing this early is very important. Also keep in mind that because the query is happening monthly, it's important to take a look at the data as it's refreshed. Medicare Advantage plans, they have people going in and out of them yearly. Sometimes Medicare beneficiaries can change plans more frequent than that. And that's why, even though Medicare is only going back 3 years in enrollment history, they're saying there could be up to 12 plans involved because there's all kinds of particular special reasons why Medicare beneficiaries can change plans. So make sure that your best practices at your organization are in line to take a look at this PAID Act data, to act on it. We've worked with some clients that work with some TPAs and or work with some claim systems where the data is not being passed back and not being shared. So if you're not aware if you're receiving this data back, or if your organization's not doing anything with this data, we highly recommend it and reach out to us if we can help you. Kathy, you want to talk about quarterly reporting and reportable claims?
Great. So quarterly reporting. So again, the query process is done on a monthly basis. Quarterly reporting is done again quarterly. Depends on when your RRE is set to report, but who has to? So it's any applicable plan that basically is handling those liability claims, your no-fault claims, which again include MedPay and PIP, and then your workers' compensation plans. So it's important that you are reporting that information. They are referred to as RREs, your responsible reporting entity, and you're going to report that information on those reportable claims. So your ORM is yes, or you have a settlement that's over 750. Those are going to get reported over. What claims should be reported? So again, any Medicare beneficiary claim, that has ongoing responsibility medical and that TPOC. The coverage, just so that everybody, kind of understands, Medicare basically has 3 plan types. So they're looking at the plan types E, which is for your workers' compensation. They're looking at the plan type D, which is your no-fault claims, again, MedPay and your personal injury. And then your plan L, which is your liability plans. Keep in mind that Medicare, you can have like a no-fault and a liability claim that you're reporting on one claimant. So you want to make sure that you are reporting those separately and they are getting over to Medicare on that quarterly basis, and that you're providing them, again, the updated information as they go along. So some of the common areas or common, Section 111 errors that we see kind of starts with that query process. So again, you need that, those big 5: first name, last name, date of birth, social security number, and gender. Probably social security number is the most critical, especially for the liability people. It's sometimes difficult getting that from those, claimants because they don't want to provide it to you. Keep in mind, we do have some services that we can help you in trying to get that information, but you do need to have, either the social security number or that MBI, and, get that into your system. And then another one that I think is really important to understand is the invalid Social Security numbers. We see a lot of Social Security numbers that start with a 9. Medicare will never issue a Social Security number that starts with a 9. Typically what we've seen is anything that starts with a 9 is possibly a work visa, and they've given you that. But you want to know, Medicare will never issue one that's 1, 2, 3, 4, 5, all 4s, all 5s. They're not going to issue Social Security numbers like that. And you want to be aware of if you have claims in your data that have those invalid Social Security numbers. And again, make sure that you're documenting your effort to try to get the correct Social Security number if they have one. If it is a work visa and they're not a U.S. citizen, then they, are not likely in, a Medicare, they're never going to be a Medicare beneficiary because they're not part of our system. So, but it's just so important, again, that you're getting that information as quickly as possible and getting it updated so that it can go through that query process. Some of the reporting errors that we're seeing is the ORM indicator. It's either missing or it's incorrect. We had a program that they had reported all work comp claims with ORM as no. And it was just an issue on, in their system. And so we worked with them to get that cleaned up because again, that claim's not going to ever be reportable if ORM is no, and then there's no settlement. It's never going to get over to Medicare, and that's going to be a concern. Your ICD codes. Probably this is one of the most sensitive areas. We have to report at least one ICD code, but you want to make sure that you're correctly reporting all your ICD codes. You don't want to over-report, so you never want to just take what's listed on a medical bill and report all of those codes, because there could be a lot of unrelated codes. The person goes in to treat and they list, that they have heart disease, they have diabetes, and the doctor lists all of those. And if you list them, then Medicare is going to use that information for that conditional payment recovery effort. So you want to be careful in doing that. You also don't want to underreport. So you want to make sure that you are reporting all body parts that are related to that claim. So all injuries. And then, not updating it through the life of the claim. So again, if their condition changes and they have additional, issues that you need to report, you need to make sure you're updating those ICD codes. Or if one resolves as you're handling the claim, you need to make sure that you're removing it if it's fully resolved and you have the documentation to support that. And then termination of ORM. You can't stress enough, this is so important because this tells Medicare what the coverage period is for their conditional payment recovery efforts. And that's terminating ORM when it's an indemnity only settlement. So if that settlement does not include fully releasing medicals, you do not want to terminate ORM based on that. Terminating without sufficient medical documentation. Again, you just have a medical report that says MMI treat PRN. That's not sufficient enough to terminate that ORM. Administrative closing, just because you close your file does not terminate ORM. And you can't use that date to terminate ORM. You have to, again, have the documentation that supports the criteria that CMS has given us in order to terminate your ORM. And then failing to, put in the no fault exhaust date. So, if you terminate ORM because you've exhausted the limit, but you don't put in that ORM exhaust date, that's going to cause some issues. So you want to make sure that if you exhaust that limit, if you've paid out the $1,000 medical payment limit that you had, make sure that you're putting in that date. And then late reporting, late reporting of the settlement, the TPOC that includes medicals, and then again, not entering that, corresponding ORM termination date, not updating it when the statute of limitation runs, or you have another policy reason that you can terminate that ORM. And then, capturing the Social Security numbers late. If you are getting ready to settle that claim and you're just now putting in that Social Security number, you're kind of behind the 8 ball because of the fact that by the time it goes through the query process, you get that back, you're probably ready to settle that claim, and now it's going to delay things. So, again, just being really proactive and trying to get that information is going to be very helpful.
Great. So yeah, as I mentioned earlier, CMS is working off of the Section 111 data to drive their conditional payment recoveries, right? It's important to understand that the BCRC was the primary contractor that was only handling Medicare's conditional payments before 2015. But in 2015, the Commercial Repayment Center started handling the non-group health plan recoveries during the pendency of claims. So, right, so starting in 2015, we started seeing the CRC pursuing recovery of conditional payments on open ORM claims, right? And then post-settlement, the debt does switch back to the BCRC. So just know that everything that's going into the Section 111 is being shared with CMS's contractors. So it's really important to make sure, we've talked about this and we've definitely beat a dead horse, make sure you're reporting accurate ORM termination and making sure it's timely so that we're avoiding civil monetary penalties and so that we're telling the contractor when we're truly a primary payer. And then also, when you receive conditional payments from Medicare, you know, generally we know they throw everything but the kitchen sink in there. But at this point in time, we want to make sure that we're disputing any unrelated conditional payments. We have a success rate at Sanderson Firm of removing over 80% of conditional payment charges on conditional payment demands because there are so much that is unrelated. And also, if you don't respond timely to these conditional payment recoveries, the debts can go to the Treasury. We can have interest and penalties, potentially have a lack of success on the appeal. So it's really important to stay in front of this, you know, ultimately in the long term. So some top tips for Section 111 compliance. These are our main tips I hope you take away from today. And then I'm going to turn it back over to Lisa. She's going to show you some of the issues that we're seeing when we're doing our audits of our clients on their Section 111 programs. You know, it's totally abnormal, I think, to not have a perfect process for Section 111, but you know, knowing where those areas need to be worked on and where there needs to be some progress and some updating is important to do this now, right, in 2023 before the final rule comes. But remember that all claimants should be cleared for Medicare status, right? It's a misconception that individuals only over the age of 65 can be on Medicare. There's plenty of Medicare eligible individuals under the age of 65. Make sure you're documenting your efforts to obtain Social Security numbers. Again, timely termination of ORM. And just because you've administratively closed a claim doesn't mean you can terminate ORM. You need to meet one of the ORM termination criteria that Kathy mentioned earlier. Make sure that you've got best practices in place for data management and integrity. Again, remember that the Section 111 data and conditional payment aspects are certainly intertwined. Make sure you've got best practices in your company for handling Section 111 data and timely handle all reporting errors, because failure to address errors could result in penalties.
So those of you who may not be aware, Sanderson Firm offers a Section 111 reporting solution. It combines our sophisticated technology platform, but it includes hands-on MSP expert oversight. We want to ensure accurate, timely, and complete reporting to Medicare. At Sanderson Firm, we understand the challenges and the complexities that organizations face when it comes to your Section 111 reporting. And that's one of the reasons why we developed our reporting platform to assist all of our clients, whether it be with a manually reporting client or if you would like to have a system integration with your Section 111 into your claims system. Our proprietary data logic actually duplicates Medicare's logic, and we try to get you the errors, you know, beforehand. We don't want you to wait to the last minute, you know, when it comes time for your quarterly cycle to start correcting errors. So we want you to be able to have those CMS errors before the reporting comes up, allowing you time to get the errors corrected, which will decrease the likelihood of penalties for late reporting, inaccurate reporting, or excessive errors. We also feel it's equally important to have a vendor that provides expert oversight into your data to ensure accurate reporting. And our expert oversight processes enhance communication. It improves your data integrity. It offers ongoing education and training on Section 111 compliance and industry updates. And some of the advantages of using our platform, it includes, you know, you'll have clear visibility into your data. Our portal's very user-friendly. It provides you with data management tools and reports. It also provides a proprietary data pre-validation for your monthly and quarterly reporting. Very easy to understand error reports that you can pull out of our system or that we can send over to you monthly. I think the most important part is not only just the Section 111, but having that oversight to assist our clients with that additional data integrity review and assistance with error management and resolution of the errors. And then the ongoing education and training of the staff. We know that you hire people, new claim staff comes in and goes. So we want to be sure that they're constantly educated and training takes place. And like Heather mentioned before, the best practices review. If you don't have it, we can help create those. Also inside our Section 111, we provide the Medicare Advantage plan information. Inside the Section 111, we're able to customize data exchanges, assist with error correction and data cleanup, as well as the SSN and date of birth research service.
We at Sanderson, we also provide, a Section 111 audit service. So we can get, specific data points and then kind of go through and look to see if there's any potential gaps or issues that, may exist in your Section 111, just kind of give you some insight into that. We kind of at the bottom there, provided just some examples of, the magnitude of what, $1,000 per day per claim for failure to report, how that could be impacted. You have 4 liability claims that had a TPOC greater than 750. It was missing the SSN, so we don't know if they're a Medicare beneficiary or not. I mean, that's over $1 million. 15 liability claims that were, basically, potentially reportable based on age, and when the TPOC date was, that's over 5 million. So you can just see it's so important, with the data that's getting into your system, and that it's getting reported timely, because that really can impact, these fines and penalties. And so again, we can look at your Section 111 data and your claims information and kind of give you some insight as to what we're seeing as far as your reporting.
Yeah, I think these audit highlights are really important to note. I mean, these are real scenarios that we've uncovered through our audit process. And so, like I said earlier, it's super normal, very normal to have some gaps in compliance with your Section 11 program, but now is the time to make sure that we've got that in order. Lisa, you want to just share a little bit about our services overall outside of reporting, and then we'll jump to, I think we have a minute or two for some Q&A. I see we've got a lot of questions, so but we're getting close on time.
Oh yeah, definitely, Heather. We're for people that aren't aware, we are a national woman-owned law firm that's dedicated exclusively to providing comprehensive Medicare-related services. So we offer an extensive range of specialized services dedicated to cater to, unique needs of our clients. Our services range from Section 111 reporting to lien identification and resolution, whether it be with Medicare, Medicare Advantage, Part D, healthcare liens, Medicaid liens, as well as MSAs, alternatives to MSAs, medical cost projections, as well as settlement release review, MSP opinion letters, best practices review and creation, legal consulting, as well as benefits coordination for claimants that are having issues with their benefits being coordinated, and as well as the SSN and date of birth research service.
Great. Well, in case any of you want to reach out to us after the presentation, here's all of our email addresses. Why don't we pick about maybe 1 or 2 questions that we have 2 minutes left for, Lisa, that you think we should address, and then the rest we will certainly get back to after the presentation.
Sure. The first question I see is can you please clarify the criteria for setting ORM to yes? I feel I'm confident knowing when medical payments are 750 or greater, but I'm unsure regarding the associated lost time working. Do we set ORM to yes when any amount of indemnity is paid? Does it have to be over the statute time frame? Is it any amount of indemnity, or does that have to be over 750 as well?
So Heather,
I'll let Kathy take that. Yeah.
So it is, and this is referring to the ORM, the work comp ORM exclusion. So again, this is for work comp claims only, and the indemnity is based on your statutory, waiting period for indemnity. So if it's less than that, then it would meet the criteria. If you don't have a statutory waiting period, then it is 7 days, and it doesn't matter the amount of indemnity that you pay. It's just if it's within that time frame. So that kind of drives that if that claim is reportable. So if you paid indemnity for 7 days and you had a 7-day waiting period, then you would have to report that claim regardless whether you paid, $500 on the medical portion. That claim would then not meet all of the criteria for that work comp ORM exclusion rule.
All right. The next question, is there any concern with clarification that treatment is now included in the parameters for ORM assumption that Medicare also stated that medical payments do not have to be paid or a claim need to be submitted for ORM reporting to be required?
So again, clarification of what Medicare just released in the version 7.2 was that to assume ORM, you had to, you know about the claim and you know that person treated. And so you don't have to actually have made medical payments and the claim doesn't actually have to be submitted to you. But if you are aware that that claimant received treatment for that injury that's related to the incident, then you need to report that ORM if you have that coverage.
All right. Next question.
Perfect.
Oh,
I think we're at 2:30, Lisa. We should be mindful of everyone's time. Thank you, everyone, so much for joining us today. I'm sorry about our technical difficulties and that you weren't able to see Lisa and Kathy's beautiful faces, but definitely next time. And we will get back to you on all of those additional questions that were not addressed. And thank you all so much for your time and for registering today.